Let me give you 3 tips on how to transfer your stuff at the time of your death. Hi, I'm Guy DeMartino. I am a Northwest Indiana estate planning and probate lawyer, and I was recently asked this question from a potential client. So I figured if they had that question, you may have that question. So, the easiest way to transfer stuff at your time of death is to make sure that you are not the sole owner of whatever it is. So, number 1, if you have limited stuff like bank accounts, retirement accounts, life insurance, you can transfer that stuff by beneficiary designation, by pay on death designation. So you go to the bank, you go to your financial planner, and you say, when I pass away, I want my stuff to go to so-and-so and so-and-so. So that is beneficiary designation. The second way, if you have real property, we don't call it a beneficiary designation. We can transfer that property at your death without having to go into court by a transfer on death deed. So what you would do is you would quit claim your home to you, transfer on death to whomever you want to leave the home, to child A, to child B. So Guy DeMartino, I quit claim the house to Guy DeMartino, transfer on death to child A and child B. At that point in time, child A and B just need to go to the recorder's office and prepare an affidavit showing that I passed away and the house becomes theirs automatically. The third way would be if you have stuff that you really can't transfer by beneficiary designation, or if you have property in multiple states and the state besides Indiana where your property is located does not have the ability to do a transfer on death deed. And that would be that you can set up a revocable living trust. And a revocable living trust is just an agreement between you, the settlor or grantor, and typically you, the initial trustee, and the successor trustee saying, I want my stuff after I pass away to go this way. So you may want to look at it as an open box or as a little red wagon. So we would title the home and other things that you want to go into the trust. So your home, instead of being in your name individually, it would be in your name as trustee of your trust. So then after you pass, the successor trustee just picks up that box with your house in it and does what you have set forth in your trust document. If you own stock in corporations, especially if they're closely held corporations, if you have LLCs, trusts will probably be the way that you need to go, because then you can put the LLC in the trust. So then the titled owner of the whatever the instrument is for the LLC is you as the trustee, or the same thing as to the part of the corporation. So then the successor trustee can go ahead and wind down the LLC, sell the LLC, transfer your portion of the LLC to other owners, or your portion of the corporation to other owners, and they can do that all without court intervention. If you have something that is titled in your name only at the time of death, depending upon the value of the company, you may need to go in court and open a probate estate, because a probate estate gives the executor the legal authority to transfer property. So if you want to avoid probate, make sure you have all your beneficiary designations in order. You have your real estate in order, whether it's by transfer on death or whether it is by titling it into a trust. If you have any questions, you can always reach out to me. I am Guy DeMartino. Have yourself a great day.